Hello everyone, greetings of the day. Hope everyone is doing well. My name is Mansi Chheda and I'm from Inspection Department. I'm going to speak about Prevention of Money Laundering Act 2002, that is PMLA. I will be covering topics on Introduction to PMLA, SEBI Master Circular on AML issued on 3rd February 2023, PMLA guidelines and alerts generated by NSDL. As we are aware, PMLA came into force from 1st July 2005. The notification rules under the SAD Act were published in the Gazette of India on 1st July 2005 by the Department of Revenue, Ministry of Finance. Its FIU, that is Financial Intelligence Unit India, is the authority to implement the said act. The act is applicable to all the banking companies, financial institutions, and intermediaries associated with security market and registered under Section 12 of SEBI Act 1992. ML measures is also emphasized by international regulatory agencies. FATF, that is Financial Action Task Force, is a global money laundering and terrorist financing watchdog. So now let us understand why the act came into force. First, to prevent money laundering, combating the channelizing money into illegal activities, to provide for matters connecting and incidental to the acts of the money laundering. So now, what is money laundering? Money laundering, as per Section 3 of PMLA, means whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actively involved in any process or activity connected with the proceeds of crime and projecting it as an unattained property which shall be guilty of offense of money laundering. There are three stages of money laundering. First, placement. Second, layering. Third, integration. So now let us understand what are the forms of money laundering. Hawala, bulk cash smuggling, fictional loans, shell companies and trust, real estate, gambling, and fake invoicing are some of the common methods of money laundering. Now we will come to next slide, which covers SEBI Master Circular on AML. One of the prime important requirement of PMLA is appointment of principal officer. Depository participants are required to appoint principal officer. It is advisable that principal officer is in a senior position and able to function independently and has an authority. Name, contact address, email ID, designation is required to be informed to FIU India and NSDL. In case of any changes, depository participants are required to inform FIU India and NSDL as well. So now we will understand what are the responsibilities of principal officer. The principal officer has various responsibility as he is considered as person for ensuring compliances with PMLA. Principal officer would be playing an active role in identification and assessment of potential suspicious transactions and shall have access and be able to report to the senior manager. Now, there is one more requirement of appointment of designated directors. Depository participants are required to appoint a designated director. Who all are included in designated director? The managing director or a whole-time director duly authorized by board of directors if the reporting entity is a company. The managing partner if the reporting entity is a partnership firm. The proprietary if the reporting entity is a proprietary firm. The managing trustee if the entity is a trust. A person or an individual, as the case may be, who controls and manages the affairs of the reporting entity if the reporting entity is unincorporated association or a body of individuals, and such other class or person as may be notified by government if the reporting entity does not fall in the above category above. This slide covers documents to be covered in the policy. Policy is one of the important documents. So now let us understand what are the documents to be covered in the policy. First, policy should cover client acceptance policy and client due diligence measures. Measures for identifying the clients. Third, risk management. Fourth, monitoring of transactions. We will be covering in detail in the upcoming slides. It may be noted that depository participants should review the policy on timely manner. Let us go to next slide. The next slide is of policy of acceptance of clients. Depository participants are required to keep in mind while drafting policy for acceptance of clients following points. First, DPs have required to ensure that no account is opened or kept open in fictitious name or in an anonymous name. It is advisable that the clients are categorized into low, medium, and high risk on the basis of risk. Factors of risk perception in terms of monitoring suspicious transaction of the clients are to be clearly defined with regards to the client location, that is registered office address, correspondence addresses, and other addresses if applicable, nature of business activity, trading turnover, etc., and the manner of payment for transaction undertaken. Clients of special category may, if necessary, be classified even higher. They are generally non-resident trusts, charities, companies with having close family shareholding, etc. Politically exposed persons are also included in CSC category. These clients require high degree of due diligence, such as timely access to client identity date, prior approval of senior manager in management in case of PEP client, regular update of KYC, etc. These are the few ways which DPs may also explore other ways to enhance the due diligence. DPs have to obtain documents and other information for different classes of clients depending on the perceived risk. DPs are required to perform due diligence by visiting clients when there are suspicious of money laundering or financing of terrorism. Process of identification of clients. DPs are required to obtain sufficient information about person who beneficially own or control the securities account. Verification of client customers' identity has to be done based on reliable independent source of document, data, or information. DPs shall apply a risk-based approach for mitigation and management of the identified risk and should have policies approved by their senior management, controls and procedures in this regard. DPs shall also monitor the implementation of controls and enhance them if necessary. The suspicious transaction monitoring and reporting. Depository participants shall ensure that appropriate steps are taken to enable suspicious transaction to be recognized and to have an appropriate procedure for reporting suspicious transactions. While determining suspicious transactions, the DPs shall have a guided by definition of suspicious transaction contained in PMLA rules as amended from time to time. Now, what are the lists of circumstances which may be in the nature of suspicious transaction? This list is only illustrative, and whether a particular transaction is suspicious or not will depend upon the background, details of transactions, and other factors of circumstances. First, the clients whose identity verification seems difficult or clients that appear not to cooperate. Assess management services for the clients based in high risk jurisdiction, substantial increase in business without apparent cause, clients transferring large sum of money or from overseas location with instructions for payment in cash, attempted transfer of investment proceeds to apparently unrelated third parties, unusual transactions by CSEs, and business undertaken by offshore banks, financial institutions. So what now we will look now we will go through what is a monitoring mechanism. Any suspicious transaction shall be immediately notified to the designated or principal officer within the depository participant. The notification may be done in the form of detailed report with specific reference to clients, transactions, and the nature reason of suspicious. Depository participants are required to analyze the alerts sent by NSDL and file the suspicious transaction reports in appropriate cases. Depository participants are required to ascertain the transactions alert intimated by NSDL on fortnightly basis as suspicious nature, if any, and submit the report directly to FIU India within 7 working days of establishment of suspicious. Depository participants to inform NSDL about the number of STRs filed by the DPs with FIU India for the month by 7th of the following month in the format given below to the ID Principal Officer NSDL at nsdl.co.in. Reporting format for CTRs and STRs have been developed under FinNet. In order to facilitate depository participants for complying the provisions of PMLA, NSDL is providing alerts to participants on fortnightly basis. This facility is available on iAssist under the option PMLA Alerts Download for the participants to download the alert for current and past 5 fortnights. The alerts are made available on iAssist within 5 days after the end of every fortnight. That is, for example, for the fortnight 1st to 15th day of the month, the alerts will be made available by 20th day of the month. And for the fortnight from 16th to end of the month, the alerts will be made available by 5th of the subsequent month. So now let us discuss about the alerts shared by NSDL with DPs. Below are the few of the alerts shared with DPs. First, details of debits due to off-market or IDT transfer in a single transaction or series of transactions executed in an account. Details of credits due to off-market or IBT transfers in a single transaction or series of transactions executed in an account. Details of debit due to off-market or IBT transfers in a single transaction or series of transactions executed in an account which exceeds 10 times the average size of transaction. Details of credit due to off-market or IDT transfers in a single transaction or series of transactions executed in an account which exceeds 10 times the average size of transaction. Details of transactions in a single transaction or series of transactions executed in demat, remit, and pledges. Transactions in dormant account. Additionally, NSDL also generates alerts with respect to off-market on reason code, that is, alerts are apparently different from the reason code declared by the clients and purported reason of transaction. Important areas to remember: depository participants shall take appropriate steps to have an internal mechanism for proper maintenance and preservation of records and information so that it allows easy and quick retrieval of data and requested as and when requested by competent authorities. The records have to be maintained and preserved for a period of 5 years from the date of transaction between clients and DPs. DPs are required to ensure that the staff appointed do not have suspicious background and are competent to do their duties. Depository participants are requested to provide trainings on AML and CFT to its staff. Depository participants are also required to ensure that the trainings of the staff is ongoing and are adequately trained. In case of any queries, clarification, please reach out to us on participant-interface@nsdl.co.in. With this, I conclude my presentation. Trust this would have been helpful session. Thank you.